Hello everyone, I'm Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School. What I would like to do now is to provide some background information that should be helpful as you work through the materials for Class 2 of Contracts 2. Let's not forget where we are again. We are now in Contracts 2 and we started with the concept of integration and its parole evidence rule. The idea there is a writing that looks like it represents the final agreement fully final, or may it be supplemented in non-contradictory ways by prior or contemporaneous discussions, writings, emails, etc. And you look at things like a merger clause, also known as an integration clause. If the contract says this is the final manifestation and nothing we talked about beforehand is part of this deal, that is solid evidence, although not always dispositive, that nothing prior to or contemporaneous with that writing can be used. It's only this piece of paper. What else was important along with the merger clause? Don't forget that you've got two different theories. There's the Willistonian legally formalistic approach, which is not as flexible. Let's look within the document to see whether or not it's fully integrated. There's the Corbin approach. I like to use the French term mélange or mixture. And that, under a Corbin approach, a court, because remember, a court makes the first decision on whether or not there is integration. If there is integration, the court keeps out the other evidence that's prior or contemporaneous. If it's not integrated, the court can allow it in, and then the real fact finder, whether it's the jury or the court in a bench trial, can consider it to determine what the parties meant. But the first question is, can you look at those things that came before or at the same time? Or must they be excluded? And the court makes that decision. Afterward, a fact finder can take over to determine what the parties did and did not mean. Okay? But the Corbin approach, which is more flexible, would look at everything to determine whether or not the contract was open or closed. If it's closed, we can't look at it. But let's look at it to see whether it's open or closed. So the court will look at everything to determine what the intent, the language, and whether or not that writing was intended to be the final and only manifestation of the party's contractual intent. And if the court looks at everything to decide it was fully integrated, then it takes all the things it already just looked at and throws them away and cannot use them. If, however, it finds that there is integration, then your fact finder can look at it to determine whether certain things that are not contradictory can in fact be used to supplement or explain, to add to the terms of the agreement. To interpretation, and you also have to keep in mind the tests, that's the Willistonian test and the Corbin-esque or restatement second version, the one being formalistic, the other one being a much more flexible. But going back to that interpretation now, after the integration question is decided, or the facts that you're looking at make it irrelevant. It's not an issue. Look to see if anything in the contract is being argued as ambiguous. And if it is, remember the ultimate goal is to honor the intent of the parties. That's not an element, that's a goal. We need to know, and if it's ambiguous, we have to figure out that intent. If it's unambiguous, if a particular term or phrase has a very common, very clear meaning, stop. Don't go further, and don't believe the other party who's trying to change the interpretation. And from their own thought processes, there is one case in contracts in Class 2 that points out perhaps some of the faults in a court thinking that it knows everything. I'll talk about that more in class. I may turn off the recording as I'm explaining that particular concept. But the court can look at a dictionary, right? The court can look at the four corners at this point. This is where Willis really comes in. Even in a Corbin test, if everything is clear on its face and nothing really looks ambiguous, even though one party argues that something is, if it's not, court can stop right there, give it its meaning, and move forward with the case. Okay? If something is ambiguous and it's not explained well by something else in the contract, here's how Williston would work. Let's say there's a term in Clause 3 that's not quite clear. What if there's a contractual annex, Attachment 1, that lists the nature of the products? What if that Attachment 1 explains exactly what the term in Clause 3 means? Then we're still looking within the four corners of the document And we don't have to look at anything else. It's not quite clear in Clause 3. It's made fully clear in the attachment. Thank you. We're done. Move forward with the next argument, counselor. Okay? What if that's not possible and a dictionary doesn't help? Then, by its very nature, resort to external sources are necessary. You can ask the parties what they both thought. And if it's contentious, they'll have different ideas. You can look at brochures. You can look at emails. You can look at other things. The Corbin test, the restatement second test, would be extrinsic sources. Okay? By the way, this is a little trick. Whenever you're talking about the integration issue and looking at prior or contemporaneous things, use the term parole evidence for those prior or contemporaneous things. When you're talking about interpretation, use the term extrinsic evidence. Okay? Parole evidence is a subset of extrinsic evidence. But if you use parole evidence for integration and you use extrinsic evidence for interpretation, you will have, even if you recognize it or not, been properly using terminology, and it will make any answer you write, wherever you have to write it, look much, much more intelligent. Okay? So if you can't get your mind around it, just remember the rule. But Corbin looks at a melange again. Let's look at it all to determine what the parties meant or didn't mean. Okay? Let's see. Who decides interpretation? Well, again, the court is going to determine whether or not it is possible to resort to extrinsic evidence. Okay? If the answer is yes, then the fact finder, whether it is a jury in a jury trial or the court in a bench trial, will then decide what is intended based on the looking at just the document itself, right? And determining that it's clear. Forgive me, that was actually an integration analysis. And unfortunately, we all make mistakes, including me, when we do this, because the courts, you'll note, have a lot of confusion. There's really a lot of overlap between integration and interpretation, and it's very, very difficult to keep those cleanly separated. Even I have problems sometimes. So if you do, don't worry about that too much. I'm somewhat flexible with certain overlaps. Okay? But there are some notes and questions on pages 575 and 576 that I think are quite helpful, and I think they bring up a lot of good points with regard to the interpretation issue. If unambiguous, you don't use extrinsic evidence to try and prove what was meant. You simply go with the definition. There are also rules of construction. Let's just say it's very difficult for a court to determine what the term means. And it's hard to believe the parties because each has a different interpretation. Both sides have some basis in fact, so it's difficult. Or you are in a Willistonian legally formalistic jurisdiction where the court wants to look at things in writing and does not want to look at extrinsic evidence. In either of those cases, courts can look at rules of construction. Those are general rules developed over time that are legal truisms with regard to contracts law, which go a long way to help determine certain issues. For example, construction against the drafter. If there is a word that is ambiguous, and the court has a very difficult time to determine what the true meaning was in the minds of the parties as they signed up on the agreement, as they contracted, and it, for some reason, simply cannot grasp onto one side's version. It can rely on a rule of construction, such as construction against the drafter. Drafter, this term is ambiguous, it's not clear. I can't figure out what it is as an intelligent judge. I don't see a good reason, or I will not, look at extrinsic evidence, for whatever reason. And all I have here is the fact that you wrote it, you left it ambiguous, and it's your mistake. So I will construe it against you for your mistake. You should have been clear, you were not clear. And that confused the other side, it's confusing us here, and brought this case before this court, arguably to waste our time. And it was your fault, you could have fixed it, or you might have even made it purposefully vague. to try and trick the other side into something. And then the court's not going to have very much sympathy. Another one, expressio unius est exclusio alterius. The expression of one thing is the exclusion of another. So for example, you have a term, and it could mean 2 or 3 things. Okay? In the agreement itself is mentioned one of those 2 or 3 things. Mentioned once, mentioned twice, mentioned 3 times, same thing, the only one. So now we had a term that may have been ambiguous with 3 possible interpretations. But later in the agreement, we have reference only to the first one. Well, the expression of one is exclusion of the other 2. Okay, that's another rule of construction that courts can use to determine how to interpret what would otherwise have been an ambiguous term. Another one which is shows up in the materials for today's class and is very important is a construction that avoids forfeiture. And this is often used in the context of language that is either a condition or a promise. And I mentioned this in Contracts 1. I will mention it again next week when we talk about conditions. But if a condition is not met, it either prevents someone's duty from arising. If you don't deliver it by Friday, my duty to pay does never arise. Or it can cut off if it's a condition subsequent. I owe you, I'll be paying you, but if you don't do this, my duty to pay you stops. Okay? But that ends. That's a forfeiture, right? Something ends. A mistake in one area ends the duty of the other party. That leads to forfeiture of something. The forfeiture would be to the party that made the mistake or didn't satisfy something. But still, you can see the loss. If it is a promise, you get damages, but you still have to perform. I still have to pay because you broke a promise, but a promise doesn't stop me from having a duty. It may reduce my duty, however, so I can reduce what I pay you. The remedy for a promise is damages, not the end of the legal relationship, not to my legal duty. So you see, with a promise, you may have damages, so a lower amount, but you still have an amount, so it's not forfeited. With a condition, the duty to pay may never even arise, or it may be completely cut off, which is a forfeiture of the other party who then gets nothing. So to avoid forfeiture, if it's not clear, there is a strong preference for courts to interpret language as a promise, requiring both to perform but allowing one damages, rather than as a condition, which allows one party to completely walk away from its contractual obligations based on the breach of a condition. So avoidance of forfeiture is one of the examples of a rule of construction, and it is almost always, if not always, brought up in the context of when you have some obligation, and the question is it interpreted as a condition or is it interpreted as a promise? Okay, that's probably the most important situation where you'll see that particular rule of construction. Keep in mind that parole evidence, extrinsic evidence can be used to prove fraud, duress, defenses, the existence of conditions, for example. It also, the parole evidence rule, the extrinsic evidence rules do not bar evidence of things that are subsequent to the making of the contract. So if you see a potential modification, it is not barred by the parole evidence rule. It doesn't run afoul of any extrinsic evidence rules with regard to interpretation. Don't forget the intent, or don't forget the goal. Determine the intent, right? Keep in mind the hierarchy that courts use. Courts begin a certain way to determine whether or not something's ambiguous. And then if it is, courts then, usually as a matter of first course, can decide that. And it's only after that that courts will either go to rules of construction and or, if they can't use rules of construction, at least in a Corbin jurisdiction or restatement second, they can go into looking at all the extrinsic evidence to which the collective mélange may then explain what was intended. Okay, there's some. I'll talk about UCC when we get into class, and I'll see you later in the week.